Hello and welcome to the Wisconsin Ag Law Update. I'm your host, Kelly Wilfert, coming to you live from the University of Wisconsin-Madison. Today, we'll be diving into the latest legal developments impacting our farm community here in Wisconsin. Whether you're a farmer, agriculture professional, or simply interested in agricultural law, we're glad you're here. Before we get started, I would like to give a quick disclaimer that this presentation is for educational purposes only. It will provide general information and a general understanding of the law, not specific legal advice. There is no attorney-client relationship between you and the presenters or you and the university. This presentation should not be used as a substitute for competent legal advice from a licensed professional attorney in your state. Now, I am a licensed professional attorney in your state, but as I like to say, I am an attorney, but I'm not your attorney. All right, with that out of the way, what can you expect today? We have a lot to cover in a short amount of time. To put this into perspective, one of my favorite ag law updates is a continuing legal education program for agricultural attorneys that runs over 3 days and offers over 50 hours of agricultural law topics. We have 1 hour. We won't be able to cover everything, but I've chosen 30 topics that are relevant to Wisconsin farmers. On the right-hand side of your screen, I've added a list of upcoming topics, as well as a timer that's going to help us keep moving. You'll notice that not all 30 topics are listed here. As we start to filter through these topics, you'll see new ones pop up on the bottom. All right, let's go. The very first thing that I would like to start with is a quick overview of the sources of law that we'll cover today. You might be most familiar with statutory law, which is the law that's made by the Wisconsin legislature or Congress. However, the executive branches also have the ability to create administrative law, which is what we commonly think of as regulation. These are the rules that might come from the U.S. Department of Agriculture, the Wisconsin Department of Agriculture, Trade and Consumer Protection, the Wisconsin Department of Natural Resources, or the other acronym agencies. Finally, the judicial branch creates common law. Courts help us interpret the laws, and those interpretations set a precedent for how the law will be interpreted moving forward. We call that precedent setting stare decisis. Our schedule for today is going to cover each of these categories: federal legislation, federal regulation, federal case law, state legislation, state regulation, and state case law. However, before we begin, we have a special guest with us today, Leonard Polzin. Leonard is the Dairy Markets and Policy Outreach Specialist with UW-Madison. A final decision on the federal milk marketing order has been published, and dairy farmers are being asked to vote by December 31st. Leonard is here to tell us more about what that vote means for dairy producers. Leonard? Unfortunately, we did have a bit of a glitch with recording, and so Leonard's presentation was not recorded. However, we will provide a brief summary of the federal milk marketing order update below, as well as to registrants of the webinar who will be receiving this recording too. Moving forward, keep in mind that you can ask questions in the chat or the Q&A function, and we'll circle back to all questions at the end. Let's dive in. Up first, federal legislation. Important to know is that the 118th Congress ran 2023 to 2024. So that means that we are currently in the second session of the 118th Congress, also known as 2024. Right now, we're currently in the lame duck period. The lame duck is the period between Election Day and Inauguration Day. We have legislators who will not be returning to Congress, who might be eager to try to get things done. And we also have legislators who are waiting for their majority to perhaps take over and are trying to do as little as possible until they have that power control again. So the lame duck, because it's an election year, is typically a little bit slower. We don't have quite as much activity. However, The House is expected to be in session for the next couple of weeks through December 19th, with the exception of Friday, December 13th, and the Senate is expected to be in session through December 20th. Now, one of the things that we can research is the number of bills that were proposed and how they were handled during the 118th Congress. If we search for farm or agriculture in federal legislation, we only find 9 bills that became law during the 118th Congress, nearly all of which were for appropriations. Again, given that this was a lame duck year and folks were focusing on elections and waiting for the new Congress to begin, this isn't unusual. But note that there were over 1,000 bills that were introduced during the 118th Congress. One of the things that I want you to know is that today's presentation is going to focus primarily on legislation and regulations that have actually been passed or adopted. As you may expect, there simply isn't enough time to cover the thousands of proposals that are made over the course of the year. I will be providing a survey for you at the end of the program for you to give feedback. If there's an interest in future discussions containing more policy, you'll be able to provide those comments then. But again, for today, we're going to focus on legislation and regulations that have actually been passed or adopted. We mentioned that Congress is still in session here for a couple of weeks, and they have a lot to do. Not only do they need to address funding for the federal government to prevent a government shutdown, but we also are hoping that they'll pick up the Farm Bill. So let's talk about the Farm Bill a little bit. The last Farm Bill, the 2018 Farm Bill, expired in September of 2023. A one-year extension was passed. In May of 2024, the House introduced their version of the Farm Bill, but nothing further was really done. The extension expired September 30th, 2024. A couple of weeks ago, the Senate introduced their version of the Farm Bill, although it sounds like the Republican senators, which is important since the Senator Stabenow who introduced the Senate Farm Bill is a Democrat. It sounds like the Republican senators are not really interested in picking up that Senate Farm Bill. However, a letter from 17 Republican governors that was released on Monday called on House and Senate leaders to pass a new Farm Bill now, rather than waiting for 2025. They essentially said agriculture is at a point that we need updated provisions. What was done in 2018 simply doesn't work. However, the alternative and what could happen is that they pass another one-year extension. We do expect that Congress will do something in the next couple of weeks related to the Farm Bill, because if Congress fails to act, then on January 1st, permanent law goes into effect, reverting to those commodity programs that were written in the 1930s and 40s. One of the biggest issues that's often mentioned with permanent law is the dairy cliff. Under the law, USDA would be required to buy dairy products to help boost the prices, and the mandated price for milk would jump to right around $50 per hundredweight, effectively driving private buyers of milk out of the market. Because most Congress people want to avoid that happening, because it simply wouldn't be good for anyone, we expect that there will be either an extension or they will need to pick up and pass a new Farm Bill. But it remains to be seen and is anyone's guess what will happen. The next item I'd like to talk about under federal legislation is the Tax Cuts and Jobs Act of 2018. This legislation was passed and made into law during the first Trump administration. And while it had several permanent provisions, there also are a number of expiring provisions, including the reduced income tax rates, the increased standard deduction, some changes to the bracket, child tax credit expansions, alternative minimum tax, the 20% deduction for qualified business income, bonus depreciation's begun to phase out. And the one that I'd really like to talk about is the Unified Estate and Gift Tax Credit. The Tax Cuts and Jobs Act increased the Unified Estate and Gift Tax Credit, nearly doubling it. So in 2024, that Unified Estate and Gift Tax Credit is set at $13.61 million per person. In 2025, it's set to be $13.99 million per person. But in 2026, it's expected to return to pre this piece of legislation levels, which is only about $7 million per person. The USDA estimates that the percent of farm estates owing estate tax would increase from 0.3% to 1%, which they also estimate that it would be an increased tax liability of about $647 million that would be owed by just 424 farm estates. Now, if you are a farm who is looking at estate planning, the key things to know here are that the Unified Estate and Gift Tax Credit provides an exemption for you. So you can exempt up to, in 2024, $13.61 million of assets per person before any federal estate tax is going to be applied. Now, if you have assets over that amount, you might be looking at a portability portability election so that you can use your spouse's estate and gift tax credit as well, allowing you as a couple to pass over $27 million to whomever you'd like upon your death. There are possibly ways to plan for this, and so individuals may wish to look at some planning in 24 and 25 while they can still take advantage of this increased tax credit. However, there is also discussion that with the Republican majority taking over, that tax updates may extend this. But again, that remains to be seen. Moving on, our next segment is federal regulation. And we will start with the Corporate Transparency Act. The Corporate Transparency Act was passed a couple of years ago, and in order to implement that law, the Financial Crimes Enforcement Network had to promulgate a rule or draft a rule. And so their rule for beneficial ownership reporting was issued in 2022 and effective in 2024. However, what is most important on this slide today is to know that just yesterday, December 3rd, a federal court in the Eastern District of Texas found the rule to be likely unconstitutional and issued a nationwide preliminary injunction, meaning that the government can't enforce the reporting rule and that the January 1st, 2025 compliance date is no longer in effect.
Additional cases are pending in other courts, and so it is likely that this ruling will be appealed. It may eventually end up before the Supreme Court, but at this time, there is no need to comply. And this is the beneficial ownership reporting related to entities.
So the worker protection rule is another rule that we'd like to talk about today. So in April of 2024, the Department of Labor issued the Improving Protections for Workers in Temporary Agriculture Employment in the United States. There's been an ongoing lawsuit about this since that time, arguing again that the rule essentially created collective bargaining rights for H-2A workers, which was in direct conflict of the National Labor Relations Act. In August, a district court in southern Georgia issued a preliminary injunction prohibiting enforcement in certain states and with respect to certain entities. And then now, just last week, a district court in southern Missouri granted a nationwide injunction prohibiting enforcement. So much like the beneficial ownership reporting rule, it was originally an injunction that just said the plaintiffs of a particular case did not have to conform with the rule. Both the beneficial ownership reporting and the worker protection rule injunctions have now been expanded to nationwide injunctions. Our next regulation for today that we're going to talk about is the 45Z Clean Fuel Production Tax Credit. This tax credit applies to qualifying transportation fuel produced after December 31st, 2024 and sold on or before December 31st, 2027. Producers of clean fuel were the individuals that were going to be able to claim this credit if they could provide certification from an unrelated party demonstrating compliance with certain requirements, supply chain traceability, and information transmission requirements. We probably have heard this more thinking about sustainable aviation fuel. That might be the other phrase that you've heard related to this. Some of our farmers in Wisconsin were already being asked whether under 45Z or an earlier version of 40B to sign certifications about their farming practices if their crop was going to be used in this clean fuel production. We were expecting IRS guidance on 45Z and how emissions would be calculated by January 1st. However, a recent report has indicated that the current administration will not finalize these guidelines before January. That does leave it open again to some question about what will happen with this credit under future tax legislation, as well as how would a new administration handle a potential regulation. Another regulation that we'll talk about today is the voluntary labeling for U.S. origin claims. The USDA Food Safety and Inspection Service, FSIS, finalized a final rule to define when meat, poultry, egg products, and voluntary inspected products may have a label that says the product is of U.S. origin. The two particular labels were product of USA and made in the USA. And FSIS went ahead and released their rule, which is saying that you can use those claims, product of USA and made in the USA, on your food label for a single ingredient FSIS regulated product if it is derived solely from animals born, raised, slaughtered, and processed in the United States. And then in a multi-ingredient product, all of the FSIS regulated products in that multi-ingredient product meet that original requirement. So they're derived from animals born, raised, slaughtered, and processed in the United States. And then all other ingredients, other than spices and flavorings, are of domestic origin. And the preparation and processing steps for the multi-ingredient product have occurred in the US. Now, if folks are interested in using those claims on their product, compliance is required January 1st, 2026. So there is a little bit of time there to get into compliance with that rule. The next regulation we will touch on is the electronic identification for cattle. A final rule was made effective November 5th, 2024. This is related to that transition to electronic ID as the official ID for cattle and bison. These electronic identifications must have both a visual and electronic component. And as of about a month ago, RFID tags or 840 radio frequency identification tags were the only tags that were meeting those requirements. That being said, RFID tags with another country's code are official and should not be removed. So this is applying to U.S. cattle. I've got a little bit more information there about which cattle this applies to. But if you're interested in this, I would actually encourage you to go to that go.wisc.edu link, and I will go ahead and drop that in the chat. Our livestock team hosted a webinar a couple of weeks ago with the state veterinarian, where they provided some really great insight about how to comply with that rule. And so I will not debate the experts when they've already handled it. All right, we have made it through about half of our presentation and we're moving into our federal case law update. A couple of real interesting cases here. The first one we're going to start with is what we call Loper-Bright. So Loper-Bright was a case that went to the Supreme Court, and it answered the question, when does a federal court need to defer to an agency's interpretation of a statute that it administers? So again, we talked about the idea that the legislature makes the law, and then the agency might help administer it by creating some additional rules. And in order to do that, sometimes our statutes are a little ambiguous, and so the agency might have to interpret it. Under past law, which followed Chevron, a case that was decided in 1984, the court had to ask, does the plain language of the statute answer the question? Is it ambiguous, or does the statute tell us exactly what needs to be done? If the statute doesn't tell us and it is ambiguous, then the court would ask, is the agency's construction permissible? Is it a possible interpretation? Under Loper-Bright, the court essentially said, we gave more respect to the agency's than was necessary. And so instead, courts need to exercise their independent judgment in deciding whether an agency has acted within its statutory authority. The court does not need to defer to an agency's interpretation of the law simply because a statute is ambiguous. I will say we have a scholar at Wisconsin, the University of Wisconsin Law School by the name of Anuj Desai, who did a lot of research on Chevron. And one of the things that was very interesting about that is cases tended to use Chevron as a catch-all. So courts sometimes said, Chevron, we're using Chevron, we're following Chevron, but would still do whatever they thought was best. So we're clearing this up here that courts need to exercise their independent judgment. A little bit of discussion about that. Like I mentioned, the court that decided Loper-Bright, again, the current Supreme Court, said that Chevron afforded more than respect to the agencies, and that they believe it is the judiciary's job to interpret the statutes, not the executive branch or the agencies. So what does this mean practically for us? So under Chevron, we sometimes saw interpretations being changed depending on the administration that was in office. So as that executive branch changed, sometimes the interpretation did too. And again, part of the Supreme Court's rationale here was that it's not fair to keep moving the goalpost. We need to look at what the quote unquote right interpretation is and give our citizens something to rely on. Now, this does mean that some interpretations or some legal positions or regulations that were previously sort of blessed by Chevron are now going to be a potential target for litigation. The Supreme Court said that the mere fact that a case relied on Chevron is not going to be sufficient for overturning it, but it certainly weighs in as a possibility. Keep in mind that this is different than our deference, which was challenged in 2019 and was not overturned. So Chevron and Loper-Bright relate to the interpretation of a statute. So how does an agency interpret a statute? Our deference was related to an agency's interpretation of its own regulation. And so there the court said it makes a little bit more sense since they wrote it. They might have some history to understand what they meant by that regulation. So it'll be interesting in the regulatory world to see what happens with many of these regulations moving forward. The next case that I want to talk about is the Coudray Lakes Association and the La Coudray Band of Lake Superior, Chippewa versus Rosalind Zawistowski, who is a cranberry grower in northern Wisconsin. Now, there is some history between these two parties. The Lakes Association and the Lake Coudray Band of the Lake Superior, Chippewa have previously had litigation with the Zawistowskis related to concerns about pollution, essentially. And in this particular case, they have decided to attack irrigation and use the Clean Water Act as the vehicle for doing this. So the Clean Water Act prohibits the discharge of pollutants from a point source into navigable waters of the U.S., unless it's in compliance with some other sections, and including prohibiting point source discharges that are not authorized by the terms of a National Pollutant Discharge System Elimination System permit. So in Wisconsin, it's the Wisconsin Pollutant Discharge Elimination System permit. Now, under the Clean Water Act, irrigation return flows are exempt. They're not considered a violation. However, the plaintiffs here, the Lakes Association and the other plaintiff, have said, well, the water is used for frost protection, pest control, and harvest. When our cranberry growers are flooding this marsh, that's not irrigation. That's frost protection, pest control, and harvest. And so when they put that water back, it's not irrigation return flow. It's a discharge event, which contains phosphorus, which is polluting the bay. Now, the Zawistowskis, the cranberry growers here, had already talked to the Wisconsin DNR and the US EPA, who told them that cranberry marshes are not point sources, they don't regulate the marshes, and that they're not going to give them the permit. because it's not something that requires a permit. Interesting case here. Currently in federal court, there are additional dispositive motions due on Friday, but right now a trial on the case is scheduled for June of 2025 if it's not resolved. For our cranberry growers, I think this is a really interesting and potentially important case. If a court would decide that that water is not being used for irrigation, our growers then may be subject to getting these permits in the future. Another sort of quasi case law piece to include here is the National Association of Realtors settlement. So a settlement, of course, is not case law. It's not necessarily binding. But what you will see here is that based on the settlement, realtors around the country went ahead and agreed to make some changes to their practices. So the class action lawsuit that was against the National Association of Realtors said that there was a conspiracy between the real estate trade associations and the national real estate broker franchises, and that by essentially listing broker compensation, they were causing inflated residential real estate commissions, which simply wasn't fair to buyers. Now, the National Association of Realtors never did say we disagree. Well, they did say we disagree with it. They never admitted or said that they believed it to be true. However, they essentially said, look, forget it. We'll make changes. We'll settle. It's not worth spending more time in litigation over this. So the settlement agreed that the multiple listing services, so where you might see home listings or land listings, they're going to remove agent compensation offers from the listings. They updated all the real estate forms to clarify that commissions are negotiable and buyer agent compensation must be disclosed ahead of time, agreed to, and objective. Now, if you're saying, well, Kelly, why are we talking about this if it's a residential situation? Almost all of the Wisconsin real estate forms have been updated, which includes the farm sale documents and the bare land sale documents. So this is just a heads up that those forms have been updated, and we will want to encourage our farmers to pay attention to them and understand what their rights are as they may be working with real estate agents. All right, our next case is related to the USDA, and I will admit we had a lot of USDA staff register for today's event, and I shuddered a little bit to call it USDA discrimination. So let's be clear about what this case was. Strickland versus USDA, a case that was decided in the Northern District of Texas in 2024. In this case, the farmers and certain entities alleged that they were discriminated against by USDA's use of an emergency relief program that allocated more funds to farmers of certain races and to female farmers than it did to white male farmers. Specifically, at the time that this case was decided, ERP 2022, Emergency Relief Program 2022, was still in effect. They did also reference 7 other USDA programs that were not in effect at the time. That U.S. District Court in the Northern District of Texas said, look, we don't decide constitutional questions if there's another grounds on which to get rid of the case. They didn't find any other grounds, which meant that they had to evaluate how likely were the plaintiffs to succeed on an equal protection claim. And they decided that the plaintiffs were likely to succeed on an equal protection claim and granted an injunction. What that means is that USDA is enjoined from making or increasing payments based on its socially disadvantaged farmer or rancher designation under the ERP 2022 program. The USDA can still apply progressive factoring on future relief applications if it's done independently of the protected classes. So the reason I want to talk about this one is what that court did was they said the plaintiffs were likely to succeed. They did not necessarily say that they are not the final decision makers at this point on whether it was constitutional or not. There will still be most likely more litigation to come. But at this point, USDA is not able to make payments under ERP 22 that are calculated based on socially disadvantaged farmer or rancher designation. All right, and one last, I'll say, quasi case law update under our federal case law is going to be just a quick update on Chapter 12 bankruptcy cases. So Chapter 12 is the category of bankruptcy for family farmers or family fishermen that allows them to reorganize their business. So the way that that process works is that the farmer files their petition and the schedules of their assets and debt, and they receive an automatic stay upon filing. That means that creditors essentially stop getting paid and can't collect at that moment. The debtor or the farmer here then has to propose a repayment plan that's going to take about 3 to 5 years. And then they're going to bring that plan to the court and ask for confirmation or approval that this plan is acceptable. Creditors can object, but it doesn't necessarily mean that the court won't overrule those objections. The next stage then, of course, is to actually implement that plan and follow it for that 3 to 5 year period. And if the farmer follows it during that 3 to 5 year period, we would see the discharge of debts at the end. Now, what I really wanted to talk about is the number of bankruptcy filings. So we saw a large number in 2020, but that has steadily decreased over the last couple of years. So far, there have been 2 filings as of September 30th, 2024. So pretty consistent with 2023, but we do want to keep an eye on Chapter 12 bankruptcy as we go into a more difficult farm economy. All right, with 20 minutes left, we are moving on to our state updates, starting with our state legislation. The first item that I want to talk about is the state budget, and that's in large part because we're in the middle of that process right now. So the state of Wisconsin's budget covers a 2-year period. So the next budget is going to run from July 1st, 2025 to June 30th, 2027. This fall, state agencies submitted their budget requests to the Department of Administration, who then compiled those requests for the governor to look at. Now, the governor is required to deliver the budget to the new legislature on or before the last Tuesday in January, although in some cases it can be extended, but that budget should be signed and effective by July 1, 2025. So now is the time, if there are interests in the state budget, now is the time to be paying attention to that and having conversations about it. Got a couple quick recaps here as far as other state legislation. Was Farm Service CDL that was extended from 180 days to 210 days that can be used. We also had an update to county land conservation committees, removing the requirement that county land conservation committee include the chair of the county farm service agency. Instead, the county board must appoint one person engaged in an agricultural use. That actually came down, I believe, from federal. I'm seeing someone with their hand raised. And Aaron, I know that you maybe have background on this. So let me I'll allow you to talk quick because Aaron is with the Department of Ag, Trade and Consumer Protection. Aaron, did you have a comment on that? We can't hear you, Aaron. Okay, well, still nothing. If you want, Aaron, if you can type a message in the chat to me, I'd be happy to read it and see if it's something we can share. The context that I was just going to add to that County Land Conservation Committee is I understand that guidance came down from the federal government or from USDA, indicating that there might be some questions about the appropriateness of a Farm Service Agency chair being on that committee as a requirement. And the last one, under the quick recap, I wanted to highlight that the law created a healthy food incentive program that provides a food stamp program recipient with additional benefits when that recipient purchases fruits and vegetables at an eligible retailer. So that is something that for folks who are perhaps selling fruits and vegetables may want to keep in mind to see if they can qualify for working with that program. Moving on to our next piece under state legislation, I wanted to talk about some of the updates to farmland preservation. These changes were effective December 8th, 2023. The legislation decreased the minimum term for farmland preservation agreements from 15 years to 10 years and increased the amounts of tax credits that eligible landowners may receive. It also expanded eligibility for the credits to land that is subject to an agricultural conservation easement that has been purchased by DATCP. So if you're interested in farmland preservation tax credits, DATCP, or the Wisconsin Department of Agriculture, Trade, and Consumer Protection, has a number of great resources on that topic. Another update by our state legislature was to amend section 71.056B25 of the Wisconsin statutes. And I know you're all thinking, I know exactly which code section that is. That code section covers capital gains on a state income tax level. So historically, that provision excluded capital gains for transfers of farm assets if the transfer was between persons related by blood, marriage, or adoption within the third degree of kinship. So that's children, grandchildren, great-grandchildren, siblings, nieces, nephews, parents, grandparents, aunts, and uncles. That section previously allowed for individuals, corporations, and trusts to take advantage of that opportunity, and the revision simply expands that exclusion to assets that are held in a partnership or LLC. So LLCs are in some ways a newer legal tool, and so this was just an update to make that a similar process. Keep in mind that that does not include any amounts that are treated as ordinary income for federal income purposes, such as depreciation recapture. And again, this is only on the state income tax level. So that doesn't necessarily apply on the federal level. That change, though, was made effective in March of this year. The next piece that I will talk about is the fluid milk product weight limit exemption. So this piece of legislation authorized the Department of Transportation to issue annual or consecutive month permits for essentially overweight exemptions for vehicle combinations that are transporting milk, meaning that they can transport up to 98,000 pounds. That date was effective March of 2024. And again, keep in mind, the key here is it authorizes the department to issue permits in order to do this. And one last statutory update is going to talk about the remote notarization of estate planning documents. So this piece of legislation amends the law to provide for remote witnessing and notarization of estate planning documents. So things like your power of attorney for healthcare, a will, via a virtual setting. So not necessarily seeing someone in person. It does require two-way real-time audio-visual communication. So for example, if you were signing a document right now, you can't say, Kelly, can you notarize this? Because I can't see you. It's not two-way communication. And it's not both audio and visual. The process still requires the notary to confirm the identity, if possible, to have each party make a visual sweep of the location they're in, because we want to see if there's anyone else there, perhaps pressuring them to sign. And then, of course, display the estate planning document, make sure that the notary is seeing the signing, and then the document must indicate that it's being executed pursuant to the act, and it must be supervised by a licensed Wisconsin attorney in good standing who completes and attaches an affidavit of compliance. So previously, remote notarization was an option for some pieces of or some documents, and that's primarily coming about from roughly 2019, 2020. But this provided for an expanded option for estate planning documents. Farmers who may not be local to an attorney that they're working with may be interested in using this provision for remote signings. All right. Aaron's letting me know he inadvertently raised his hand. Thanks, Aaron. So sorry about that, everyone. It's tough. We've got so many good people on this call. I hate to not defer to other experts when we have them. So we'll move on to some updates on state regulation. And as you can see, we're getting near the end of our time, starting to dwindle on our list on the right of topics that are coming up. So the first update under Wisconsin regulations that I'd like to talk about is the migrant labor updates. So the Department of Workforce Development has rules relating to migrant labor, which help ensure that migrant labor camps, transportation, and field work are safe for workers. These rules have not had a significant update, according to the department, since 2007. So instead, they did implement some changes. The rule was effective February 1st of 2024, and it relates to a whole host of items, such as the location of food preparation areas, sleeping quarters, ventilation, mobile homes. It also set some guidelines related to washing machines, dryers, refrigerators, urinals, and showers, including things like the ratio of how many must be provided depending on the number of migrant workers. It clarifies some toilet and hand washing facility requirements, including when they must be provided in fields, provided some requirements for disease and illness protection. It also added heat illness training and prevention plan, shade, and certain breaks in temperatures above 80 degrees Fahrenheit. And I believe there was another level set at 95 degrees Fahrenheit. But those particular provisions also included a repeal provision. So they were effective February 1st, but repealed and made ineffective as of January 1, 2025. So I think we'll be watching to see what happens with that in the future. The new rule also allows some additional requests for variances, adds some procedures for hearings on denial of migrant labor camp certifications or administratively assessed penalties. So again, Department of Workforce Development says this is the first significant update since 2007, but something to keep in mind. The DNR and the Department of Ag, Trade, and Consumer Protection have also been busy. So they added some farm conservation standards. So under state law, the Department of Natural Resources establishes agricultural performance standards and prohibitions necessary to limit non-point sources of pollution. The Department of Agriculture then is charged with prescribing conservation practices to implement the standards. Effective June 1st, 2024, the Department of Ag added Silurian bedrock agricultural performance standards, updated some of the cost share language and rates, and then clarified and simplified some existing rule provisions. Up next, not much of an update, but we did have a number of questions, actually, folks who were interested in learning about if there were any changes to rules related to wolves. So there is an emergency rule from the Department of Natural Resources related to wolf hunting and trapping season and regulations and a depredation program. That was effective back in August of 2012 and stays in effect until there are permanent rules in place. No change is really apparent, so the emergency rule remains in place at this time. We do then have an update on bulk milk. So this is actually one of the few proposed rules that I did include, and it's simply due to the timing. So the Department of Ag, Trade, and Consumer Protection submitted this proposed rule on November 21st, and there's a public hearing scheduled for next week, December 9th. Essentially, the department identified some changes that were needed to update the rules around bulk milk collection, sampling, and transportation to align with some of the modernization that's happened with the industry, making sure that we're getting up to current industry practices and matching those regulations appropriately. They proposed to overhaul the definition section, again, modernize some licensing and documentation requirements, updates some licensing and fee structures, and just enhance some provisions to ensure proper food safety. One of the comments from the department was that this rule aligns Wisconsin's regulations with the U.S. Department of Health and Human Services Grade A Pasteurized Milk Ordinance, or PMO, which is required to be allowed to ship Grade A milk and milk products in interstate commerce. So I think our dairy farmers probably are appreciative of DATCP staying on top of that so that we continue to be one of the leaders in milk. Up next is another proposed rule, an emergency rule proposed by the Department of Ag relating to providing crop insurance premium rebates for planting cover crops. The law provided for rebates of $5 per acre of a cover crop planted for crop insurance premiums paid on those acres. So again, this is one of those situations where the legislature passed something and now the department is being asked to actually implement it. This rule allows them to do that. Comments are open on that rule through December 28th, but a public hearing is scheduled for this Friday, December 6th. So if that's something that is of interest to you and that you want to provide comments on, those are the venues to do so. With that, we'll move into our last section for the day, our state case law update. We have 3 cases here that I'm going to talk about. The first is a right to farm case. This was a Dodge County case where 2 neighbors, last names Schmidt and Buchholz, and if I'm saying that wrong, I apologize, own rural properties next to each other. They have a road in between them, and a drainage tile runs from Buchholz's property under the road through Schmidt's property and then drains off of it. But it was damaged on Schmidt's property in 2019. And so the neighbors got together and said, you know, Schmidt's going to help pay to replace the tile since it occurred on his land. But he didn't. He did not replace the tile, and both properties had significant flooding and other debris buildup. Buchholz claimed that Schmidt breached their agreement to replace the tile, and in doing so created a private nuisance and trespass, but Schmidt claimed that the agreement wasn't valid anyway, and that Buchholz then engaged in conduct that diverted water onto Schmidt's property because he naturally diverted the water that was building up on his own and created a private nuisance and trespass. So we've got cross claims in this lawsuit here. They're both very upset with each other. Now, the alleged nuisance creating activity was conducted on Schmidt's land. And Buchholz said that because he didn't fix this property or fix this tile, it interfered with his ability to farm his own property. And Schmidt attempted to raise the right to farm defense. So the right to farm defense under Wisconsin law is a defense that says an agricultural use is not a nuisance if it was being done on land used for agricultural purposes prior to the plaintiff coming to the property being affected, and the activity does not present a substantial safety or health threat. So what has to happen? We have a nuisance claim, and then a farm says it's not a nuisance because it's an agricultural use and I was doing it before you got here, or someone else was doing it before you got here. This land was an ag use, and so you can't be upset because you came to the nuisance. That's how right to farm works here in Wisconsin. There was a question about whether drainage activity can be an agricultural practice, and Schmidt argued that it couldn't based on a case from a couple of years ago. But what the court said is that the issue with that case was that it wasn't an agricultural use, but it doesn't mean that drainage activity can't be an agricultural practice or an agricultural use. And the court said, the Wisconsin Court of Appeals in July of this year said, drainage activity in this circumstance was an agricultural practice. So the alleged nuisance creating activity happened on Schmidt's land, interfered with Buchholz. The issue then was whether the land was in agricultural use before Buchholz began farming his property, and Schmidt didn't present any evidence to prove that, and so he doesn't meet the requirement for protection under the right to farm law. We won't get into the details of the contract claims, but if you're interested in seeing just what happened, how the court worked it out, you can read that below or on the recording. The second case that I want to talk quickly about is the Wisconsin Cottage Food Association versus the Department of Ag. This was an opinion, a slip opinion from November 2024, so just last month. Not clear yet if it's going to be published and create precedent or not, but certainly I would expect so. So Wisconsin law requires folks who are looking to prepare and sell food directly to consumers for profit to obtain a license. There are some exemptions, but in 2016 and again in 2021, a group of plaintiffs tried to expand those exemptions. And the case at issue here was the 2021 case where, let me make sure I click the right button. The plaintiffs alleged that the retail food establishment laws were unconstitutional, being applied to them as sellers of unbaked, not potentially hazardous homemade foods, such as fudges, candies, energy bars, roasted coffee beans, and dried soup mixes. DATCP filed a motion to dismiss in March of 2021, argued that the laws were rationally related to the legitimate state purposes of public health, safety, and welfare, promoted food safety and consumer confidence, and the protection of consumers. The circuit court denied, but DATCP appealed, and ultimately the Court of Appeals of Wisconsin held that those laws do not violate equal protection or due process, again, because they were based on a legitimate purpose of protecting public health. I'm going to jump through this because of time and more information on that case and the rationale, but we've sort of covered that. Let's move on to our farm succession case, which was an unpublished case in 2023, but always a good reminder. So in this case, we have a family farm. Mom and dad own the 180-acre dairy. The son and his wife return to the farm, and mom and dad make a verbal promise to sell the farm. Son and wife begin making payments, but it turns out mom wasn't tracking them. They never put the deal in writing. They just said their word was good. And ultimately what resulted was promise after promise was made, but dad died first. Mom decided she wasn't going to leave the son the farm. And when son found out, he consulted an attorney about pursuing his claim to the farm, but he decided not to because the attorney told him your option is to sue. And he said, where I come from, you don't sue your 80-year-old mother. Mom passed away 5 or 6 years later and left the son 15 acres. He tried to file suit against mom's estate to enforce the oral contract, but the claim was denied based on unreasonable delay and lack of notice that they would bring suit. So again, this is not a precedent-setting case, but it is a reminder, document, document, document when we are working on farm succession. And finally, before we close, I just want to thank you again for attending. 50% of respondents to DATCP's 2024 Dairy Producer Survey indicated that regulations were a primary challenging to continuing milking on their farm. 63% indicated that regulations were a top challenge to Wisconsin's dairy industry over the next 5 years. And I just want to say, we hear you. So we recognize the American Bar Association ranks Wisconsin 37th for the number of lawyers per 1,000 residents. At that time in 2020, Wisconsin had 2.7 lawyers per 1,000 residents, and Wisconsin has lost 300 active lawyers since that time. According to the State Bar of Wisconsin, only 1/4 of active attorneys live outside of Milwaukee, Waukesha, or Dane counties. So we do recognize that it is a challenge for our farmers and our rural communities to get legal counsel. One of my goals in this role as the Farm Law Outreach Specialist with Extension is to continue to develop educational programming that helps inform the legal risk decisions that Wisconsin farms are making. But your feedback is key. I'm going to launch a poll for some feedback. about if you found this update helpful. It's going to be 2 questions that I'm going to ask you to answer before we dive into our Q&A. That one is going to be a short poll just based on basically the helpfulness of today's presentation. I'm also going to drop a second link in the chat. This evaluation is a roughly 5 or 6 question survey about today's webinar. Was it too short? Was it too long? Did we not spend enough time on topics? Did we spend too much time on topics? How often should we host these? And any other comments that you might have. So I appreciate you answering the poll during the webinar today, and would also really appreciate if you clicked on the link in the chat and answered our survey about what we should do with future versions of the Wisconsin Ag Law Update. With that being said, we are at time and at the end of our presentation. I am happy to take questions if there are any. I'm not seeing any in the Q&A or in the chat right now, but I will hang on for a moment, and I will also stop the recording so that if anyone would like to answer sort of offline, we can do that as well.